simultaneously. Okay, so it would be in front of the committees basically the same month.
He's talking about the current process.
In the current process, what happens is that the planning board approves an application and approves site plan approval. Okay, and then after they have, granted site plan approval, it then goes to historics, however many months later, when the applicant is seeking a building permit. And that's where the biggest problems arise. The sequence of the reviews has to be coordinated.
But I don't see how they can be done at the same time because they're doing different things. So if we had the combined committee look at it and then we get their blessing, then if it goes to planning after that, wouldn't that make more sense? Does anyone else see it that way?
Well, simultaneously means at the same monthly meeting. So, HLPC would be addressing it in January, the planning board would be addressing it in January, and when the approvals are granted, the applicant can then go to the building department and secure their permit without then having to go to yet another committee.
That's the coordinated review terminology that he's been using at work. That's what coordinated review means.
You were suggesting last night, though, at the planning board that landmarks be at the planning board meeting and that the deliberation happen the same night.
In those rare instances where the issues in front of the two boards directly overlap, they would meet together and they would determine together and share information, like what happened with North Street. Just because there are two separate reviews doesn't mean that the issues are overlapping. Historics has jurisdiction over a certain part of it, site plan has review over another part, and there are only a certain portion of the joint applications, or the applications that involve both boards, where the same issue is being addressed. And with regard to those issues, a meeting would take place where both boards would meet together, and as we did with North Street, the vote would be, basically one board would be on one side, one vote would be on the other side, and they would act in coordination. There are a number of jurisdictions where the planning board actually is the HLPC.
I'm going to just jump in, because we were talking a few minutes ago about the concierge, because this might be something, instead of saying we have to find one exact way to do every project, I'm sure a lot of the projects aren't that complicated to come to a resolution. So it would be, do you have to have them all in the same room? How do you know when that would happen? They would be able to point to when that would happen.
We don't even have enough building inspectors to determine when buildings are a risk to public safety. The idea of hiring somebody for this type of function when, I don't even have building inspectors, and Tommy comes to a meeting every month saying, I need people, and that's a decision that you all make as council members, whether you want to fund additional positions. You're regularly arguing over funding, firefighters and police officers. We don't have building inspectors right now. We are down, I believe it's 3 people in the building department, so they can't do their regular inspections of buildings throughout the city.
Right, but that's not a question of how much money, those positions are there, we haven't hired people for those positions.
Yeah.
So we see your point, but this could be something very important. And if we look at other communities and discover that there's a huge value added from having a person in this position, that would make some sense, but we need to investigate.
Right, and that's one of the premises behind this legislation is to take the entire review process out of the building department and let the building department concentrate on building code violations and bring it under the purview of the planning department, where they already have staff that does this type of work and coordinates these types of reviews. You have Kyla downstairs, you have Sue downstairs, and whether Sue ultimately, if she is managing these two committees, is going to come to you and ask for an additional person in her office to focus on coordinating these processes, is something that is basically up to the department head. But at this point, it is supervised by and supported by the building safety division of the fire department, which is woefully understaffed to do, you know, the primary things they have to do. And, you know, what Marissa said is absolutely accurate. There is no staff, there is no support, and, you know, you have to decide whether or not that's a priority, and that's the best way.
Yeah, I think if it is under the plan, if it is under their scope of the planning department, I mean, they still have, you know, they can still have access to the building, but, you know, they can still utilize that to get all the information they need anyway, so that might not be a bad idea. If that person and, you know, that added person might have, you know, could have multiple functions, we have different jobs in City Hall where people do kind of cross over and do different things. I mean, that might not be a bad idea for that person to help with the process of, you know, getting people who are in these districts that need to make changes more aware and make the process easier and quicker from that standpoint. Was it anyone else have anything on that? What do you guys think?
Are we on item 2?
Not
Yeah, we're-
exactly, I think we're covering everything.
Oh, okay.
Yeah, we're all over the place, no rules.
No rules. Well, item 2, I think, is very, is correct. There's a lot of problems with clarity and consistency. Some of that is stuff that we've added in over time. And I looked at the model law, 2014 state model law, and I think a lot of that we should just import. The discussion is just getting good.
Yeah, that's okay, I'll make the clip notes.
She'll watch it later.
I will. Have a good night.
Anyway, I think there's a lot of that material that would be good for us to look at seriously to bring into our current code.
I would suggest if anybody hasn't read the model law that you do so.
Yeah, it's
Only-
pretty detailed, you know.
It's only 32
32.
pages.
I guess I missed the last 2 pages then.
Well, 7 pages or so are definitions at the end.
Do you have that, has that been sent to us?
It has been sent to us, but if you need it
has?
again, yeah, if you can't find it, let me know and I'll.
You can
Yeah,
also
Track it
just
down.
look at New York State model,
Mhm.
state historic preservation, state model law for historic preservation.
that's what we're doing, July 2014. With the
Yeah, that's it.
Yeah.
Yeah.
Um,
Just like this.
So what were you suggesting? I mean, what's your,
I'm just saying that, you know, if we want to look at incorporating some of that material into what we've got now before us, I think it behooves us to look very closely at that and bring that in so that we're up to date.
oh, just in general, I thought you were specifically for certain.
Yeah, well, I mean, there's a couple things mentioned here. For example, the Stockade District is singled out with a description of its significance, but not the other 3 historic districts. So some of those things we would want to take care of, but just in general, the solution that they suggest here is work with the State Historic Preservation Office and use improved ordinance 2014 state model law. I'm saying I think that's a good idea.
Yeah.
And I started working on it, but I haven't finished it yet, so I'm not going to share it. But I've started working on kind of comparing what is current, what the legislation is, and then the model law. So I'll get that as soon as I can.
Yeah, I kind of started doing
Did
that
you-
too, then my head started exploding, so I stopped momentarily, but
Yeah,
Right,
so
I
I
think
mean, I'm
that's
happy to do that and then share that because that might clear up a bunch of things for people. But I do recommend reading through all of it. It really doesn't take that long to read. And what else do you have to do all day long, right? So I can get that to you.
okay, anything else on that,
I mean, I think
one
we
or two
kind
that
of,
anyone agrees with, disagrees with?
my one concern is not really part of any of these, but it's briefly mentioned the solution one is the waterfront revitalization program. Seeing how, if there's something else we could do with that. And because if we're combining these, I'm hoping that cleaning up the language, helping them, with more education if that's something that we choose to do with this. Maybe the HLPC meetings will be shorter, but right now, like the one we went to was 3.5 hours long. And I think that's average. Adding, and I know HAC is not nearly as long. Kevin said it's about 1 hour, maybe 2 hours, depending on what it is. So if we're cleaning everything up and kind of getting rid of the redundancy, that might not make it a 5.5 hour meeting. But if there's a way, the waterfront revitalization program, if I could fit someplace else. I know the CAC does not want it. I'm their liaison, and I don't think are interested at all to do that. And also, it's
Their
also
meetings were so long, they
they're
wouldn't
long
notice. No, they wouldn't notice.
I would notice. So I don't know if there's a different place for it, because the other point with that is not just the timelines, but, the HLPC committee members are very focused on the historics and the buildings, and not necessarily coastal, so if,
Right, I agree with that.
yeah, so then would that make really qualified historians and people interested in that not interested in serving, because their meetings are really long and now they're going to be longer and it's about, they just cover something that they aren't really interested in. So I'm just wondering if there's a different home. I don't know, but I haven't thought of any ideas. My first one was the CIC, but I don't think Julie poo-pooed that one down. So I don't know if anybody has put any thought into that, or if you can consider that.
We just added more members to the tree commission.
There we go. Trees and water. So anyway, that's a big concern of mine, is seeing what can happen with that.
I mean, doesn't the planning do a lot of waterfront stuff now? I mean, wouldn't that fall into that? Dams, that makes sense.
Yeah, but they can't, the coastal consistency review and the recommendations under the LWRP have to be made to the planning board. So the planning board can't do them.
So you need an advisory group to do that.
Yes. And there really is no other group that, is viable. I mean, you can go through the code and look through the other commissions. It has searched for a home for a long time, and landed with the HAC. And Sue also, is the staff person who manages the HAC, so it would basically.
So they would report their findings or
They
recommendations to the
report their-
planning
yes.
board then? Okay, so, but yes, I agree, I think that should find a new home. And we might not have an answer now, but I think we should look for one.
Yeah.
Great.
Does anyone else like that idea?
No,
Yes.
Anyone not like it?
I like it.
We can argue, it doesn't matter, we don't have to agree with it.
Could you just go over that one more time for me, Bill?
The waterfront revitalization program.
Yeah.
Right now it's under the HLPC or?
HAC.
Oh, it's under HAC, okay. And if we combine them, that's really, like Andrew said, it's not necessarily has to do with heritage or historical significance. It's more of a, I think, climate smart thing or a CAC type of
Well,
thing. So
not really. I mean, it is directly relevant to the heritage and the historic review in that they have to determine whether it's consistent with the local waterfront development plan. And it's directly within their purview and their expertise. It's not a conservation thing just because it's called the local waterfront development plan.
Oh, okay. Yeah, I was thinking it was more.
So they are concerned with the historic values of the.
And why would it have a separate category if they're looking at like the entire city of Kingston as far as historic preservation and the whole heritage, everything? What would be different from looking at a property in the Stockade District or in?
It's not part of the local waterfront development plan.
No, but I'm saying that, but it would still have to fit within a certain parameters to.
Bernie's raising his hand.
Yeah.
Maybe he.
The
understands what
difference
you're
would be obviously the stockade versus the rundown. Big difference.
Right.
There's no
That's your
water,
answer.
there's no waterfront plan.
No, but I know that, but why would that be a separate, just because it's not technically in a historic district?
It's separate because it was developed separate from Bill, that's it. And the good thing about this is it's gonna be an ordinance, and you're gonna learn as you go along and make amendments and change it. So to think that you're gonna have the best plan, it's not gonna be the best. It's good, you're gonna learn as you go along. So that's what you have to keep in mind here.
But we could do the best plan for now. I mean, I don't
Yeah,
think anybody
she's
is thinking that this
I
is
guess-
never going to change.
Right,
We
I
could
know.
still do the best plan.
I guess my point is if they're looking at the city as a whole, they're gonna have certain criteria for each area as it is.
Right.
So why is that, there's separate districts already, so what, it would, it just seems like it would just be part of one umbrella, so to speak, as far as they're gonna look at
You
how
You wouldn't
it fits.
apply the standards of the stockade to the rundown. anyway,
Exactly,
so
right,
what-
right.
It's
So-
different
Right,
standards.
so you're gonna look
but
at
it's
different, you're gonna look at it differently anyway.
Yeah.
So why are there separate categories even, like from that standpoint? I guess, is what I'm saying. I don't know. Does that make sense to that? Made sense to Jeff, I guess I got one person out of these.
But we can figure this out.
Yeah, just another point to think about.
Okay.
How many LWRP reviews does the HAC do?
Do you know, Bernie?
I don't-
Since you're the liaison?
No.
I mean, how often does it come up?
Pretty much every month,
Every month?
pretty much.
Because it applies to any property or development in the rundown or just on the waterfront?
Just the waterfront.
Just the waterfront. So it would only relate to those particular projects that were right in the LWRP area,
Right.
right? So how often does that happen?
It's infrequent, it's infrequent. Depends on what the development is in the area and so forth. So you just can't say, we're gonna have 10. We might have 2 one year, and 4 the next year, and none of the next year.
Okay.
Going on, but I think we've actually hit a lot of the remaining ones, kind of just part of conversation. So 3 is the whole project review process is inefficient and confusing, which we talked about with this, the procedures for coordinated review, how that works, who the applicant goes to first. Should it be consistently always HLPC planning? Should it be vice versa? Should they be the same month? Or if we do want to do the concierge idea, which may not be even possible, but that's, that next concern. And because that would clean up a whole lot of stuff, if the process wasn't confusing to everybody. So that's just another thing to think about, is how we want to do that, or do we want to make it, do we want to set it, I don't know if this is possible, set it where it's always in the order, or we set it where somebody determines, the planning board department determines how it goes, or if that's too much work?
I think it should be a checklist. These are the ones you need to, when you apply for a permit or something, these are the boards you need to see.
Yeah, but what,
I think
in
it
what
should be the
order,
same.
do
I
they,
think
do they
it
have
should be the same.
HLPC first, they see the planning, or does it not
I think
matter?
it should be the same order.
I think, yeah. I
What
think it
are
should
you
be
gesturing
consistent.
about behind her shoulder?
No, Dan, answer the question. He has a very good question. You have the answer.
I don't really have the
don't wanna
answer,
sit-
other
you
than
don't wanna
it's
sit
coming
up
It's a
from.
procedural one, Dan.
What's that? Procedurally, a building permit is not secured until after site plan approval is generated. So an application goes to the planning board, okay? The planning board then schedules, informs the applicant of what they need to do with regard to site plan approval and with regard to SECR. Okay, and then, it's put on the planning board agenda once the application is complete. The planning board then meets, and when the planning board approves site plan, the applicant then leaves the planning board and goes to the building department and seeks a building permit, and the building department says, I can't give you one until you go to, HLPC. So if HLPC was under the purview of the planning department, when the initial application for site plan approval was filed, the planning department would be coordinating everything.
Right, but that's what I'm
Yeah.
saying, and within that, if we merging it, wasn't arguing with that at all.
No, I'm sort of talking over your shoulder to Bernie, because
No,
they're coming,
you're
Bernie,
right.
they're coming to these conclusions on their own, which is what they're supposed to be doing, don't, you know,
No, I'm with you.
you know.
I'm with you.
So if the planning department is now overseeing all of this, we now can change the order of, if they go to HL, or they could determine it, because it's the planning board that's doing it, department, correct? Right. I just asked myself a question and answered it.
So somebody at the planning department tells people,
Here we go. Now-
this is where you
Yes,
need to
I'm
go.
done, I don't
Okay.
need you, I can just answer my own questions.
Absent a specific provision in the code with regard to when the review takes place, which it doesn't have now, an applicant will, go after they apply for a building permit. We have included in the proposed legislation a timeline where, it is done simultaneously with the planning board. And again, by putting it under the planning board's purview, the planning board, when they get the application, will inform the applicant, this is what you have to do, and this is when you have to do it, based on what the application is and based on what the work
Right, that was
is.
my question, is
Yeah,
if we
you
are
can't-
merging it and it's
Yeah.
the
Is it the
planning board.
planning board or the planning department?
Planning
Planning
department.
department,
Planning
sorry,
department. Yeah.
and I keep saying that. The planning department,
Right.
that's what I'm saying, like, if this is all under the planning department,
Yeah.
then they can decide what order
Right.
it is, it can be changed. That's what
Right.
I was talking about.
There is no, the applications and the work are fact-specific, and you're not gonna be able to come up with one, checklist or one timeline that applies to all of them. The department has to have the discretion to say, you're asking to do this is the timeline that makes sense under these circumstances.
Right,
Yeah.
I think that's a good, healthy
Yeah.
thing to do. Yeah, I wasn't arguing that.
So the answer is yes, it can change. That's
Yes.
the one for all that?
Yeah.
Okay.
And then, so that's 3, I don't know if anybody else has any questions regarding 3. You good? 4, we also kind of already talked about, there's no city administrative representation, including no common council liaison, so are you gonna follow up, should we file on? And again, this is a concern of HLPC, this is also a concern of the city, so kind of figuring out. That's why right now they have a volunteer commission and kind of doing all the administrative work, correct? Okay, thank you. And it's a lot, if you look at this list, the applicant inquiries, well, you can read it, so it's all right there, but. But that's a big decision, because that would involve money, or at least their solution, so I don't know if there's any other solution that anybody has that can help address that concern.
Budget season is upon us, so we should be mindful of that if we do want to start making some changes,
Yeah.
staffing and make it better, make it easier.
Number 6, we also already kind of started the meeting talking about the lack of public awareness of landmarks program. I don't know if this is something that would really be addressed in the legislation, or just be, the suggestions here, are they all, would they be part of the legislation?
No, I don't think so.
Right,
No.
yeah, so I don't think that's,
But this is an initiative we definitely need to take up.
yes,
Yeah,
yeah.
even if it's just, like the signage or that, even if there was like something on the corner that had like the outline of the map, this is
Yeah, or even like a few of us volunteered at Make a Difference Day, having a table, or just being part of the city of Kingston, because we had the community development people there talking about the programs that they offered, having the programs, maybe not that particular event, but having information getting out that way too. But that's not really a part of the legislation conversation, I just think that's something we should be
Yeah,
addressing
that's
too.
good, that's something we should.
Whether it's
Sure.
now or after the fact, I don't think. So that's those were their main concerns. Besides that, I don't know if anybody who was at the meeting a couple weeks ago wanted to talk about that, so I don't talk the whole meeting.
I think you've got them all. I mean, Steve raised, I think, a very good point, I think. That's the confusion that people have coming in, what are the procedures, and who do you see to do what, and it's hard enough for landowners, property owners are already here, but someone moving in, so it's.
You know, we may really have to think about what Rennie said, that this might pay to have someone in charge of this.
Who said?
Rennie suggested,
Rennie.
one of the suggestions he said, you know, one of the things he said, it might actually pay to have, it might, you know, actually pay to have someone in the city oversee this stuff and coordinate it, you know? And that might be, you know, a position we might want to talk about. And have somebody do that. I mean, it sounds like that would cure a lot of this.
Someone within planning.
Yeah.
Right.
And it might even be able to be a part-time person, I don't know.
Part-time person or 10 hours a month, whatever we decide the position is.
Would a part-time person be able to handle it? I mean, you guys are kind of doing it now on following therapists.
It's hard of hearing, you have to speak up if she's not looking.
Oh, okay. Would a part-time person be enough for
It'd be
something like that?
Huge, much better than what we have now.
You
yeah.
take it, huh?
We'll take it.
Well, because again, with a part-time person, you're just talking about just a straight salary, there's not, you know, the benefits, you can get someone, and
You
I
might
think-
get a very qualified, very interested person to do it for very little money.
And honestly, you might even get someone who might even be, you know, be retired, or say, kind of where it's more of a, you know, labor of love, so to
Ideally, the
speak.
person would have some sort of preservation background,
Right.
maybe not a professional degree, but experience working with historic preservation program in a municipality.
I think that's worth pursuing. I agree, Pat. Randy?
So I guess one thing we could be doing is checking out to see if other communities have that, and how that works. I already wrote it on my notes.
Okay. We'll get together, we'll combine those. Yeah, and I think, again, that would be the time, budget coming up, that's a simple enough conclusion, if we wanted to do that, you know, to bring someone in.
Right, that would also be outside of the law in particular. So, right,
Say it again?
that would be outside of this legislation in particular.
Oh, yeah.
So, in terms of next steps then, what we need is, if you're coordinating, if you're thinking about adding stuff into the current proposal or alternate somehow, when do you honestly think you could get a version of that done?
You mean revised resolution 107, is that what you mean?
Yeah.
And I'll help.
I mean, I could get a lot done next week because I have off from that other job I do, so.
Mhm.
Do you want a hard date? I can,
Well, wouldn't it be good if we could discuss a caucus? Is that too onerous?
I could get it done by then.
Or-
That's-
Well, we have to read it also.
Right.
So we
Well, yeah,
can,
we
we
can
can have
vote
some
it on, but-
discussion at caucus, but we're not voting on it.
Right.
Yeah.
So why don't I plan on having it ready to go July 9th?
July 7th. Because we need time to read it.
Oh,
We'll
before,
discuss it.
July 6th.
July 5th, that's my last offer.
Well, yeah, I mean, 'cause that also gives time then to tinker with it before the next laws and rules meeting. Again, and I'm not beholden to that date, that we have to release it that day for the public hearing.
Right.
If we get if we get closer, and then we look at it next month and do have a similar discussion.
I just wanted
And
to
if
check
it's similar
points.
changes, and then it's a month later, that's fine, I think.
Right, the idea of having, if we could just talk, we could touch base at caucus And then if there's people we want to invite to come and talk to us, you know, we can make sure we've got, so if we want a state representative to come down, if we want people from HLPC, if we want people who've gone through the process as homeowners, you know, we could do that at the next laws and rules meeting.
Okay, I'm not done though, I'll let you go just, I have a couple other things from the, from Marissa's May 10th letter, I just wanted to get people's opinions on. The 62 versus 45-day deadline, what does everyone think about that?
I'm perfectly.
Because even the model loss has it at 62, and then it allows an additional 62. So I think if it's, I personally think 45 is okay, because as long as there's a built-in extension there, I don't think it has to be hard and fast. But I like a shorter time frame for that.
I'm fine with either time period. My concern was more, even in the model law, it wasn't exactly clear, like, what
Constitutes an extension.
what constitutes the historic commission, what gives them the power to say, we have to have more time, how much of that is negotiation with the homeowner, right? Okay. So, or the property owner.
Anyone else have an opinion on that?
It was in our packet of stuff.
And so Bill, you're saying?
It was actually in the resolution that got sent back.
So Bill, you're saying you want to change it from 60 days to 45 days, if they have time to?
Yeah, because I think the draft, I think your draft had 45 days, right? Is that?
We originally had 30, we extended it to 45 to allow for a second meeting. The thought process was that after 45 days, either the applicant is going to consent to an extension, or the board's going to have to vote, and if they turn it down, they can, reapply. So rather than dragging the thing on, meeting after meeting after meeting, which furthers the length of the meetings and the issues that are in front, the length of deliberations, it's basically, make a decision now, or, make a decision one way or another. And the applicant is fully aware of that, and the applicant has the right to withdraw the application and resubmit it, or, put the committee to a vote.
Yeah, there's a mechanism for an extension, I think that.
If it's on consent, yeah.
I mean, typically, the applicant either A, didn't present more, proposed more than was included in the application, so we didn't have the information to judge on what they were proposing, or we get the feedback and they go back and consider that and work that into their proposal. So that's what the 45 days allows them to take our feedback if we didn't approve it at that meeting, work it into their proposal and come back, and then typically we vote on that unless they did not bring that additional information that we requested, which is on the applicant. We were specific to say, we need elevation drawings, and you did not provide this. We cannot understand this proposal until we see elevation drawing. It is on the applicant.
And then they have the option to say, I'll bring them back next month, or to say, vote without them. And, they risk, the commission just saying, just denying the application.
Well, would having a point person in the planning department, like if we do get a part-time person that does all that ahead of time, wouldn't that would alleviate a lot of the delays, because they'll know ahead of time that they need this, they need that, so
we could
shorten it.
An applicant meet with a staff person and go through the proposal. Let's say it's in addition to an historic structure, like, okay, this is what you're going to need. You need the photographs, you need elevations, you need a floor plan. Even though we have it included on the application instruction, we never get that information. And no one's there to work with them unless I flag it first, call them and say, this is what needs to happen.
Gotcha.
And then they can come to our meeting prepared. Also, what we encourage, and we've been telling people, come to us, have a pre-application meeting with our board. Come to us first, let's have an informal conversation about what you want to do. We call it workshopping. and then we say, this is what we want to see, like, okay, this all sounds good. At the next meeting, we'll put you on the agenda, this is what you need to submit with your application. So,
Well,
And the
well, I think
45
that-
days, just for clarification, the 45 days is from the acceptance of a completed application. So if the application is not complete, the 45
clock
days doesn't start running.
Gotcha.
So if particular items are deemed as necessary with the application and they're not submitted, clock never starts running.
Okay.
So I think it's important, I got you, Randy, one more point, then I'll let you speak.
Put your hand down.
Because I think the board, their decision, you know, their point is to make decisions, make rulings on these, not to hand walk through, you know, not to, so I think if we can clean that up, I think that will go a long way. It would solve a lot of problems, people who, you know, might not be aware that they need certain things, and then, again, I'm lobbying for this person that we already kind of agreed to, so I guess I should just be quiet. Go ahead, Randy.
Well, I was just trying to think if there's really a functional difference between 45 and 62 days, because in essence, they both encompass 2 meetings.
And that's why we said 45, yeah. I mean,
Yeah.
the extra 60 is just confusing because then you're gonna have people who are coming in on the 59th day and asking why they can't go over to the 3rd day.
Right.
So 45
So
basically
it sounds
covers
like
it.
everybody agrees with 45.
Yeah.
Yeah, so I don't see a huge problem there. But like I said, my main concern is in defining a little more clearly what it is that would allow for an extension for the second period, but we can talk about that later.
Yeah, that's a point well made, I agree with that. And again, we might not know the answer, because that could change, that could be something that's fluid as well. I mean, we might not be able to list all the things that would, you know, that we might just have to leave in the opinion of the board as to what they deem worthy of an extension or not. The emergency designation, I didn't know, legally, would a commission have the ability or right to do that? I know that came up last time,
No.
and it was discussed, so that.
No, in fact, the model law specifically says that they can make a recommendation to the, to the governing body, which would be you. Conceivably, you could do that. You
Yeah, the
could.
model says the building inspector would issue a stop work order, right? So only.
Right, the
so
bill,
not
well, that's different than, an emergency moratorium, that they're talking about. They're talking about an emergency moratorium on a proposed designated building. So if a proposal was made to designate, Doug's house as a historic landmark, and
Congratulations.
Doug opposed it, said, I don't want my house to be designated because I don't want to jump through all of these hoops, okay? That the HLPC, cannot issue an emergency designation of his house that stops him from doing work prior to the final process being, undertaken. Okay, that the council could, but that an administrative board can't. Okay, and, the council, as the governing body of the city is, certainly,
Isn't that what the model law, this is say what the building inspector can?
no, the model law
Stop
says
work?
that the HLPC can request a moratorium, or make a recommendation for a moratorium to the governing body, which is the council.
But this is also after there's been certain steps in the process taken.
No,
No.
no.
No, because I was looking at section 12D, it says, once the commission has issued notice of a proposed designation,
Right.
it may recommend work moratorium.
Right, so that's notice, so they're giving notice to the property owner
Uh-huh.
and the public. Okay, but that's not the formal hearings, that's not the formal, presentation, and that's not giving the owner the opportunity to contest it and say, I don't want this.
But the key is a temporary moratorium until that full public hearing process can play out. So it's not our commission requesting that the common council grant a moratorium on a building or a district while, I mean, we technically in landmark funding, which is called calendaring, we calendared a hearing for proposed district or proposed new landmark. We, at that time, the common council would vote whether to issue a work moratorium on that individual building or that district, and therefore, for that period of time, 45 to 60 days is the recommended time limit, or 90 days, that owner cannot demolish or alter the building. And that's the moratorium, that's the protection we get until the public hearing process plays out.
And that is very problematic due process-wise, because basically you are restricting a private property owner's
And
ability, let me finish, you are restricting a private property owner's ability to make modifications to their property without any due process of law. That's why it is something that only a judge should do after everyone has an opportunity to be heard.
And the municipality in the United
Right.
States,
Yeah.
that has a preservation program, grants authority within their own community legislature.
Yeah.
It does not go to a judge. That has been upheld by the Supreme Court.
No, it hasn't.
Yes, it has.
Okay, I'm not gonna argue.
Well, yeah,
The bottom line here
Well,
is
I mean,
that
I think
the
that's
landmark
that's something we
commission,
gotta look at,
Right.
we gotta get an answer.
the,
Obviously, there's a difference.
we have incorporated the language from the model law into our proposal that specifically talks about a moratorium, okay, which was the request that was made, that's what we did. To go further than what, SHPO or the model law says, our opinion is it risks serious liability, coupled with the fact that you all have to recognize that there have not been any proposed designations in basically decades. So we're arguing about something that really is not, relevant at this point. While the committee and the commission wants to go down this path, it has, Bernie, when was the last time anything was involuntarily designated as a landmark?
I don't recall anything.
Yeah, I don't think it's happened in anybody's memory. So, it's really not a central issue
So
here, and
the
it
way
certainly
Ken would
doesn't.
have it is, we're not going to have any new historic districts or landmark designations in the city ever. It's his thinking, which is
What?
insane.
No, I don't hear
Where did you get that from? Okay, the bottom line here is that the language from the model law, which is the language that has been advocated for by not only SHPO, but the committee itself, is the language we have included, okay? Asking to go further than that in an area where there basically has never been an issue is just, opening the door you don't have to open.
Right.
Well, I think this is, we just, the model law says some pretty clear things, but this would be a place where we ask SHPO, what's the best way to frame this?
Right.
And so I'm fine with going with their recommendations.
Okay, so we will do that. I will do that. Someone will do that. Yeah.
Don't look at me.
She's got something to do. I'll do it.
You're off next week.
I
You
should
should
never have
you
said
should have never
that.
said that.
We'll let you.
Okay, I just wanted to throw it out there. I'm glad I did.
Thanks, Bob.
The preservation notice of action to have a certificate of occupancy or compliance with health. Is that current, that's currently in the language on the commission where you can currently do that? Or no?
What was it, Bill?
Where it says, at present, work to protect property that does not conform to conditions, preservation notice of action can have its certificate of occupancy withheld by the building department. And it made it sound like that was originally that the commission could do that. Am I misreading that? Because that didn't make any sense to me. That's what I thought you were saying.
Can I read that?
Yeah, this one. It might just be my confusion.
So the current ordinance ties a clear stipulation, like if the work isn't completed according to what was approved, it's a clear punishment and tied to it, like your certificate of occupancy is withheld. And the new proposed legislation sort of leaves it kind of unclear what happens if you don't conform to the preservation notice of action. Sort of leaves it to the discretion of the building inspector.
Who has the authority to do that?
The building inspector.
Okay, so it would still be in the building inspector.
Well, the zoning
So,
enforcement.
but I think Dan might want to address this. I think this is a building code issue, state building code, and whatever the legislation presently in effect in the city for zoning. And I think that's the lawyer's decision, not the commission's decision.
I mean, a certificate of occupancy is completely different than a building permit, and a certificate of occupancy is based on compliance with the building code.
Right.
The code currently provides that a building permit cannot be issued without, in a historic district, without securing a preservation notice of action. It also provides, and the legislation continues to provide, that if work is done without a preservation notice of action, a report can be brought to the building department, which will investigate and determine whether or not a violation has occurred that they deem worthy of prosecution. It is then referred to my office as the prosecutor, and just like any other prosecutorial discretion, a decision is made whether or not it's something that will go to court. That process is what is currently set forth in the code, and it's the process that is set forth in the proposed code. Nothing has changed about that.
Is everyone clear on that? I'm still a little confused.
What are you confused about, Ron?
So what happens now? So someone's not in compliance now. So the building inspector can come.
Just
in
like
and
any
just-
other violation, a report is made to the building department. The building department is empowered to do an inspection and to determine whether or not there is a violation that rises to the level where they want it prosecuted. If they refer a prosecution to my office, okay, my office as the prosecutor determines whether or not it's something I'm taking to court. The same way.
So
a district
violation in this
attorney-
case really isn't a safety thing, it's more of a compliance with the
It's
code to.
proceeding
on what
with
they-
work
what they-
without securing the preservation notice of
Dan, can
action.
you
That's the
give
violation.
us an example of something that a person in a historic district, in a historic house has done that would warrant this, your department getting involved?
Well, if they,
So we have an example of it? Like somebody didn't paint their house right or didn't put the wood siding on, or is there an example? that
Or they
you-
propose to put a balcony on.
Or a balcony?
HLPC says, no, that's not historically accurate, it doesn't fit, it's out of
And
bounds.
they do it anyway.
And they do it anyway.
Right.
Then the building.
And they do it
inspector-
anyway, and it meets all the building code requirements, it meets state building code, it meets the zoning code, and, it's safely and appropriately done according to the inspection.
At
So
what
the
point
question
do
is
you
whether
issue
or
a
not the
fine?
violation of doing it without the P&A is something that rises to the level where the city is going to request a sanction from a judge or request that a judge order the work to be taken down. And that's a decision that can only be made, by a prosecutor who is appearing in front of a judge.
So the process is there.
Yeah, absolutely. And we've had situations, there are buildings now where individuals have done work without a P&A, okay, and we have prosecuted them, and the judge has been convinced that the violation was sufficiently egregious to basically direct them to go back. And there are other situations where there have been violations and the judge has said that it's not egregious enough to tell them to go back because basically the work fully complies with the code, the work needed to be done, and the judge is not going to consider, any kind of sanction under those circumstances. They're very fact specific. We have,
But before that, before the judge makes his ruling, they can revoke the certificate of occupancy?
No.
Is that-
No.
Okay, that's where.
Certificate of occupancy is
okay.
something completely different.
Okay, All right,
Yeah.
I'm good with that. And that's what I was thinking of. That seemed, okay.
You know, and those who attended the meeting last month could answer, you know, Pat's question as well. I mean, there were, you know, at least, you know, two different situations in front of the committee last month where, you know, there were alleged violations of the code with regard to, you know, work that was done or securing a P&A. You know, and, you know, a referral is made and a determination has to be made as to whether or not it's, you know, worthy of, you know, practical and worthy of prosecution. You know, we don't prosecute every violation, we can't. You know, we don't prosecute every building code violation, we can. I mean, we don't prosecute every parking violation, can't be done.
But at what point do you put, at what point does it move from just daily fines until the work is corrected to it goes to court?
We do not impose daily fines without a judge, without a judge's authorization. There are inspection fees, which are not the same as fines, okay? But fines are a penalty that should only be imposed by a judge after an accusatory instrument is filed and, you know, the property owner has the opportunity, you know, to, you know, defend themselves in front of a judge. A fine is a penalty, and the building department or my office does not have the authority to impose a penalty, only a judge can.
So let's say I'm walking down the street and I see this guy destroying this nice house that's a historic building, and I report it, and you know, obviously they're doing some things that are violations. How quickly can we get that stopped by a judge? I mean, how long would that take?
What does it, so at the last meeting, there was a couple here that they were replacing their windows. And they had already replaced some of the windows in their house. They didn't know to come here. I don't know how they found out, that's besides the point. They then came and presented, and I think the decision HLPC made was, you already replaced the lower windows. We will say that's fine, but the windows that you have not replaced, you need to discuss with us and then pass that. So it's not like any time that happens, it then automatically goes to the judge, because they then come here, right? And it could be resolved right here. So it's not like every violation is then sent off to court, or. That wasn't the answer, or the.
No, I was just wondering if there's other, you know.
The building inspector, the building safety officer
Yep.
has the authority to issue a stop work order, and he is the only one who has the authority, other than a judge, to issue a stop work order. So if you had observed a violation, just like if you observed, you know, a car parked at a fire hydrant and you called, you know, PD, okay, it would be investigated, and the city official who was charged with, you know, with that responsibility would make a determination within their discretion.
Now, are they educated to our historic?
Absolutely.
The people in the building safeties are educated to the historic preservation of the buildings, and they know what a violation would be and what it wouldn't be?
You know,
We hope they are.
educate, you know, again, we go back to, you know, money and staffing and qualifications. He is the building inspector. He is charged under the building code with, you know, enforcing the building code. He's also the plumbing inspector. He's also the, you know, the floodplain manager for the city. Okay? He wears many hats. He's also a fireman. Okay? How, you know.
Yeah, and after the building inspector issues a work stop.
Stop work order.
A stop work order. Would he then, is that just a temporary thing? Would you then still go before a judge to make it more permanent, or is that solid? Will that be sufficient?
It depends on the circumstances. Usually the building, you know, the safety officer, the building inspector will meet with the, you know, with the property owner
Okay.
and instruct them regarding what they have to do to get the stop work
Resolve
order
it.
lifted.
Okay.
And, you know, if there's
Well,
a
then ideally,
disagreement.
that's how we want it all to
yeah.
be resolved, but.
Yeah. Very rare that we actually have to go to court to address, you know, issues like this. The vast majority of them are resolved between the property owner and the building department.
Well, that's good. It's good to know.
But again, if we had a preservation person at the city, like on city staff, we could work with building department to resolve those issues.
We're with you on that.
Yeah.
We're getting on board that one. I think that's kind of all I have. Probably when we leave here, when I go home, I'll realize I wanted to bring up other things maybe, but,
We're gonna have to come back.
I don't have any. Well, you don't have to, unless you have more things that, does anyone else have anything else, or?
I have just some differences from the model law and the map, but I'll get that all typed up.
Yeah, like I said, I'll.
By
forget it,
July
'cause
6th.
I actually did find it interesting, and I think we're, I think there's a lot, I think we're a lot closer maybe than we think, and,
Bill, what's the next laws?
Yeah, month.
17th, July 17th, I'm guessing?
Does everything, because the council meeting is pushed a week, does everything else get pushed a week?
No.
So it's the 18th.
Because next, first week of July, we have caucus, council, and finance.
That's the
Bam, 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 3 nights in a row.
Yeah.
When's finance?
The 11th.
The 11th.
The night after council, Monday,
Gives
Tuesday.
you something to do, Doug. Gives you something to do.
Yeah, Monday, Tuesday, Wednesday, it's gonna be a busy week.
All right, so as you can see, we still have a lot of work to do, but I think it's good. All right, I think we're heading in the right direction. I appreciate your time and your efforts, and anything comes up, get a hold of me, get a hold of Andrea. Let's get as much as we can and
And I think
put it together and see where we're
we're
going.
gonna hammer this out,
I like that we've kind of have an informal consensus about hiring someone. I think that will go a long way in alleviating some of the pressures and some of the time and responsibilities of the board.
I think we got.
The new board, hopefully.
I think there's people in town that are very interested in this and would do it, because they want to, and there's a little bit of stipend.
There's a lot of people passionate.
You know what I mean? There's this passion for it and a little stipend, where that would go a long
Yeah.
way.
No, I agree. All right, if no one has anything else, I'll entertain a motion to adjourn.
Second.
All in favor?
Aye.
Opposed? Steve?